Understanding trademark assignment becomes essential if you're into business or brands or intellectual property. Just like any other property in which you can transfer your ownership right by way of selling it to somebody else, even in the case of trademarks, you can transfer your ownership right by way of trademark assignments. Although the concept of trademark assignment is a little more complex. So, covering all the aspects, I'm trying to fill the informational gap here by first beginning with explaining what is the meaning of trademark assignment and the scenarios in which a trademark is assigned. Thereafter, moving on to questions such as is consideration mandatory for trademark assignment and whether can you assign even an unregistered trademark, and very important difference between a trademark assignment, license and transmission. Concepts such as complete trademark assignment, partial assignment, assignment with goodwill, without goodwill, and moving on to the process, the law by which you can get your trademark assignment on record. So stay with me and let's begin. To begin with, let's first see what a trademark assignment means. It simply means transfer of ownership of trademark from the proprietor, who is also known as assigner, to other party called as assignee. Let me explain further. Suppose you start a business. You choose a brand name for your product or service that you offer, and you work very hard and build a reputation for your brand in market. And thereafter people start trusting your brand. This way your brand, that is trademark, becomes valuable. Now this valuable trademark is actually a property, because please note that a trademark is treated as a property. So you have a property right in it. That is why, just like property, ownership of which can be transferred to someone else, you can transfer your ownership in trademark also. How do you do this? It is by way of written assignment by which you transfer ownership in your trademark to the other party. And when can this trademark transfer by way of assignment take place? When a business is sold, or when a brand is acquired by some other party, or during, suppose, a restructuring of an organization. These are some of the circumstances in which trademark assignment take place. So to understand assignment better, let's differentiate it from transmission and license also. Assignment transfers ownership, whereas licensing only permits use of trademark by the other party, that is, the licensee, while ownership remains still with the original proprietor, that is, the licensor. So we see here that a license does not change ownership. In license, only permission to use is given for a specified time period. It can be for a specific territorial basis also. Whereas when it comes to assignment, ownership is transferred, given away to other party. And in case of license, the licensee pays the owner percentage of sale or fixed sum or any other payment agreement for using the trademark for fixed time period. Now coming to transmission. Just like assignment, transmission also results in transfer of ownership in trademark. But still, assignment is different from transmission. Let's understand. By way of assignment, the proprietor of trademark is voluntarily transferring the ownership in trademark to other party. Voluntarily here means that he is giving away his ownership rights by his free will. He's transferring, he's selling his ownership rights to other party in assignment. But when it comes to transmission, here there is an automatic operation of law. What does this mean? We can understand this by examples. So example of transmission is when ownership of trademark is transferred onto someone else due to death of the proprietor. Here in this case, ownership shall now vest with the legal heirs. Similarly, in cases of merger or amalgamation of companies, in many corporate mergers or amalgamations where entities dissolve to form a new one, the asset, including trademarks, are transferred automatically to the surviving or new entity as a legal consequence of the merger process. Now, another example can be if the partnership dissolves due to, say, death of a partner, the rights may devolve to legal hire or the surviving partner by law. So, in cases where ownership passes automatically, the change is recorded as transmission and not assignment. Now, moving on to the next question, that is whether to assign your trademark, the same needs to be a registered trademark, or you can assign an unregistered trademark also. Addressing this question, let me clarify that if the trademark is registered, then the registered proprietor has the power to assign it. This is what Section 37 of Trademark Acts 1999 deals with. But Indian law does not stop there. A trademark at the application stage or even an unregistered trademark can also be assigned. This comes from Section 39, which makes it clear that trademarks are assignable even if not registered. So remember this clearly. Registered trademark assigned by registered proprietor, and pending trademark is assigned by the applicant, and unregistered trademark can also be assigned. For example, let's see assignment of at the application stage. Let's say your trademark application is under examination or objected or advertised or even opposed. Even then, the application can be assigned. The assignee simply steps into the shoes of the original applicant. The stage of the application does not reset. All objections and oppositions continue as they are. So, Indian law allows assignment of unregistered trademarks. Now, moving on to next concept, that is complete assignment and partial assignment. So, assignment can also be a complete or partial one. In a complete assignment, all rights are transferred, including the right to further assign or license. Whereas in a partial assignment, the transfer may be limited to specific classes or specific goods or services or specific territories. These limits must be clearly stated in the assignment deed. I hope you are understanding the concept till now. Now let's move on to assignment with goodwill and without goodwill. If you assign a trademark with goodwill, you are transferring all the aspect of the trademark. That is the mark, the reputation and the business identity attached to that trademark. After assigning your trademark with goodwill, you stop using that mark. There is a total transfer of value. It includes not just the logo or the name, but the intangible assets, recognition, and earning power associated with it. Thereafter, the new owner, that is assignee, can use the trademark for the same goods or service that the original owner used it for. And once assigned with goodwill, the original owner, that is the assigner, is barred from using the mark for those products. So, what about trademark assignment without goodwill? Now, if a trademark is assigned without goodwill, it means the transfer of trademark ownership rights alone, without the associated business reputation, consumer base, or product specific rights. So, the assignee can use the mark but for different goods or services and leaves the original owner to continue operation in their existing market. I will explain this with an example. Suppose you have a brand ABC under which you sell dairy products, and if as the owner of ABC trademark you assign that mark without goodwill to someone else, now this buyer might be allowed to use this brand but for any other product or service, and is forbidden to sell dairy products under that brand which you are already doing. Although Indian law allows assignment without goodwill, but it is not without safeguards. The registrar can refuse such assignments if they are likely to cause any kind of public confusion. Now, going on to very important question of, is consideration mandatory in assignment? Now, what is consideration? The consideration aspect of trademark assignment is governed primarily by Section 37 of the Trademarks Act 1999, which explicitly empowers a registered proprietor to assign a trademark and give effectual receipt for any consideration, that is, money, for such assignment. While the Act itself is relatively silent on the specific amount, it establishes consideration as a fundamental prerequisite for a valid transfer of rights. From a practical and procedural standpoint, the trademark registry requires the disclosure of consideration. The assignment deed must clearly state the value exchanged, as the figure is essential for calculating the applicable stamp duty under the Indian Stamp Act. Now, moving on to next point, that is recording assignment with the trademark registry. So, recording of a trademark assignment involves filing Form TMP with the trademark registry, ideally within 6 months of the transfer, along with the assignment deed, and requires fees to update ownership records. The process requires legal proof of transfer, potential advertisement, and registrar approval to officially register the assignee as the new proprietor. The mandatory documentation involve duly stamped and notarized assignment deed, Form TMP, application for change of proprietor, trademark certificate, identity proof, as well as power of attorney if using an agent. So I hope you found the information in this video useful, and we shall meet again in the next video. Thank you for watching.